Welcome everyone to our webinar, Whistleblower Advocates. I'm Chris Oppie, a historian at the University of Massachusetts and the director of the Ellsberg Initiative for Peace and Democracy. Tonight's event is the capstone to a year-long series on public interest whistleblowing. To learn more about our work and to see recordings of prior events, please go to our website, eipad.org, which you can find in the chat. And as we proceed, you can find other links to relevant websites and articles. Our work is inspired by perhaps the most famous whistleblower in US history, Daniel Ellsberg, a former government official who in 1971 gave to the New York Times and 18 other newspapers a 7,000-page classified history of the Vietnam War that exposed more than 2 decades of government lies about the causes and conduct of the war. Those top secret documents were soon dubbed the Pentagon Papers. For that act of moral courage, Ellsberg was indicted on a dozen felony charges, some of them based on the deeply flawed Espionage Act of 1917, and he faced a possible sentence of 115 years in prison. Ellsberg was the first person criminally charged and tried under the Espionage Act for giving classified documents not to a foreign agent or foreign country, but to the American press and people. In this century, there have been many more such prosecutions. The trial of Ellsberg and his co-defendant, Tony Russo, did not go to the jury because late in the trial, the judge had little choice but to dismiss the case against them when evidence surfaced from the Watergate investigation that the Nixon White House committed crimes against Ellsberg in an effort to taint his reputation and to keep him from revealing any other secrets he might have, including some about the Nixon administration. Since then, Ellsberg devoted the rest of his long life to nonviolent activism on behalf of peace, truth-telling, government transparency, nuclear disarmament, and First Amendment rights. He died last June at the age of 92. Dan was also a great supporter of other whistleblowers and often pointed out that truth-tellers do not act in a vacuum. They're greatly impacted by their times and are often inspired, as he was, by other activists and truth-tellers. He often said, "Courage is contagious." So let me now briefly introduce the panelists. The discussion will be moderated by Caton Mistry. He is an associate professor of history at the University of East Anglia in the UK. He has published widely on the history of US national security, whistleblowing, and the Cold War. Caton has also led a number of projects to connect scholars, NGOs, lawmakers, and activists to work on whistleblower protection and press freedom. With Hannah Gurman, he published Whistleblowing Nation, The History of National Security Disclosures and the Cult of State Secrecy. He is also the author of The United States, Italy, and the Origins of Cold War. Anna Myers is executive director of the Whistleblowing International Network, WIN, a network to strengthen civil society organizations that defend and support whistleblowers around the world. WIN has 37 members in 24 countries. Anna has worked in the field of whistleblowing law and practice for more than 20 years. Under her leadership, WIN helped secure a European Union directive to protect whistleblowers. Anna is originally from Canada and received her law degree from Dalhousie University in Nova Scotia. She lives in Glasgow, Scotland. Tom Devine has been the legal director of the Government Accountability Project since 1979. He has assisted more than 8,000 whistleblowers and hasn't lost a case since 2006. He also has been on the front lines for passage and oversight of 37 whistleblower laws, both in the US and internationally. He is an adjunct professor at the DC Law School, where he supervises a whistleblower clinic. Tom appears regularly as a media expert, has written or co-authored dozens of books and articles on various aspects of whistleblowing, and has spoken in many countries as the State Department's informal ambassador of whistleblowing. He also co-founded the organization Anna leads, Whistleblowing International Network, where he serves on the board. To those of you listening, if you have questions, please post them in the Q&A box, and Caton will try to get to some of them, particularly in the last half hour of our webinar. So with that, I'm happy to turn over the discussion to our moderator, Dr. Keaton Mistry.
Wonderful. Thank you, Chris. And thanks to Ross as well for helping bring this fantastic panel together. I'm delighted to be moderating it, and it's an honor to do so with two esteemed experts. So in many ways, this is the ideal place to be talking about this topic and having this conversation. Ellsberg, as many of us are well aware, is an icon of the brave truth teller, revealing the top secret Pentagon papers, which details decades of government lying about its policies in Vietnam. He's, in many ways, the epitome of the modern whistleblower. There was also, however, a broader group providing support and assistance that helped made Ellsberg's revelations possible. The New York Times, of course, were the first to publish a series of stories based on the Pentagon papers. They were followed by many others in the press. The press, in many ways, were doing what others, including Congress, did not do in ensuring that the general public were informed. Tony Russo, who Ellsberg was on trial alongside for the release of the Pentagon papers, of course, was a fellow colleague at the Rand Corporation with Ellsberg and was one of the first to suggest copying the report. Furthermore, Russo practically helps him do so. The two of them use a Xerox machine at Russo's girlfriend's ad agency, where the bulk of the Pentagon papers were photocopied. When the authorities were on the hunt for the Ellsbergs, a group that were termed the Lavender Hill Mob helped Dan and his wife Patricia hide in the Boston area. They provide lodging, they pass messages, and help distribute copies of the Pentagon papers to others, as the Supreme Court hear a case against the New York Times and the Washington Post, and as this is playing out in court. Some of those in the group were only recently revealed in the last few years, including the peace activist Janaki Natarajan and the historian and scholar Gar Alperovitz. And when Ellsberg's case went to trial, he's represented by the famed civil liberties lawyer and the activist Leonard Badin. In short, there was a wider network that helped facilitate Ellsberg's disclosures. They're not all directly connected with one another, but all of them in their own way are crucial to Ellsberg's act. So today, what we're going to do is explore the importance of such networks. Often these are overlooked, these networks and communities that enable and support whistleblowing. And we're going to do that with two of the world's leading advocates on this. And I'm delighted to be hosting this discussion today. I wanted to start by asking our panelists how they got into the field of whistleblower protection. There aren't many majors in whistleblower protection. So I wondered if we could begin by if you could begin by explaining how you got into this field. Tom, if you'd like to kick us off.
Conceptually, it's probably because if I weren't a lawyer for whistleblowers, I'd be one, and I don't have a martyr complex. I think working at government accountability projects the only job I could have held down for a sustained period. More specifically, I was inspired when I went to a national whistleblower conference sponsored by the Institute for Policy Studies. It's a think tank in Washington, D.C., and they actually deserve some credit with Mr. Ellsberg as well. Mark Raskin, a founder of IPS, whose son Jamie is one of the more inspirational members of Congress right now. Mark helped Dan to package his papers and put it in a format that could be communicated effectively. And he inspired creation of the Government Accountability Project, which until 1983 was part of the Institute for Policy Studies. And one of their conferences that I attended with the public interest lawyer that I was working with, it was on President Nixon's attempt to transform the civil service from a nonpartisan professional labor force into a 2 million person campaign team for President Nixon's reelection. And that was exposed as part of the Watergate hearings, in part through Freedom of Information Act requests by the lawyer that I worked with, but in part through whistleblowers. And so I went to this conference and listened to these people who had put their whole professional lives on the line because they couldn't live with a truth that they were aware of but was being concealed from the public. And I just knew immediately that's what I wanted to do with my life.
Anna, could you outline how you got into this space and working in this area?
Yeah, probably a little less directly than Tom, although I agree that in the end it felt right. So there's probably only one. I've tried to actually get away from whistleblowing briefly and then just couldn't. But I think it also sort of highlights the fact that the US, there has been a long conversation about whistleblowing, because it certainly wasn't something that came up in my law degree that I really talked about. And it was only when I moved to Britain, and it took me a while to even get a law degree. So I'd done a history degree, which is why you and I have really hit it off as well, because I think the history of where these laws come from and what is promoted or pushed them along is really important. But I think in law school, I was always very interested in the relationship between the state and the individual, more than, say, corporate law as a field. And then when I saw I basically saw an ad for a charity called Public Concern at Work, which is now called Protect. I'd moved to the UK, I'd requalified, I'd traveled. I figured out in requalifying that the legal system I understood, even though it was shared with Britain, had developed differently, and that how power works in different countries is very different. And I saw an ad for this organization called Public Concern at Work, and applied for it. And when I applied for it, I was looking at what it was, because I hadn't really heard of this term whistleblowing before. And the idea that someone should be able to speak up about wrongdoing or harm, particularly in the workplace, which is where a lot of the laws are focused, and not suffer for doing what is actually their job usually, or for doing the right thing for those who might be affected by something that's going wrong within the workplace, just made sense to me. It sort of still does, as a very simple concept. And so I applied for this job 20 years ago. When I talked to people about what I did, I often didn't mention whistleblowing, because it would be a 3-hour conversation. And that has certainly changed in the last 20 years. So a bit of serendipity for sure, and something coming together. But I think now I get more, contacts from law students who are studying it, people who are doing their masters. So maybe there are people actually, making that choice more in the way that Tom did, and really interested in the issues that it presents to us as a society.
You mentioned the term whistleblower, and this is a conversation which is one that we've had over a number of years now, but it's one which I think is worth reiterating, the importance of definitions and labels, because there are a number of terms that are often used and are bandied around, and what may appear to be pretty straightforward for us when we talk about whistleblowing may not be for if we consider it from the state's perspective. So I wonder if you could just take a moment to just very simply outline what a whistleblower is. Is it just a legal question, or can we think of it as something beyond the law? Tom?
Well, there is a gap between whistleblowers' identity culturally and popular identity and their legal definitions. In popular terms, we think of whistleblowers generally as people who are dissenters, dissidents, who are pointing the finger at some sort of abuse of power. And to me, that's that's a very good definition. Our definition at Government Accountability Project of a whistleblower is someone who uses free speech rights to challenge abuses of power that betray the public trust. But freedom of speech shouldn't be limited to dissent. And officially, the whistleblower laws in the United States and most nations just talk about communicating protected information that's credible and is exposing evidence of some sort of betrayal of the public trust, from illegality to abuse of authority to threats to public health or safety, et cetera. And technically, it shouldn't matter whether or not you're finger pointing or whether you're just doing your job. Because the overwhelming percentage of communications that are technically covered by the whistleblower laws, if not in the popular culture, are people who aren't making allegations, they're not pointing the finger, they're just communicating information about problems that need to be dealt with. They found that we're operating illegally, and I thought you'd want to know about it, or we're going to endanger public health and safety, and we might want to do something about this. It's the freedom to warn that people perform as part of their professional responsibilities. That's the iceberg. The tip is just pointing the finger with allegations. And there really is a disconnect between the popular identity of whistleblowers and the official scope of their rights. And it's a disconnect in terms of enforcement as well.
Yeah, if I want just jump in there a little bit, I wouldn't add that much. And I would actually start with also what Tom has so succinctly stated for many years is sort of the definition of whistleblowing, which is ensuring the free flow of information for the responsible exercise of institutional authority. So in sort of the work we do at WIN, working with so many organizations around the world that are looking at whistleblower from different angles, I think, you know, legal definitions are necessary because you have to have some certainty and you are protecting something. So a lot of the whistleblowing will come from within a workplace or a relationship with a workplace, because that's where a lot of these issues that we're talking about, it's an institution doing something wrong or are negligent as to whether it's going wrong. There's lots of ways in which you can raise that. But I think that the issue of, you know, just in the way Tom talked about the gap definition of free speech rights, in the UK, we didn't talk like that because we couldn't communicate the information by talking about free speech rights in the workplace, because that was not really something that within the British culture was even a starting point. We talked about better governance, good regulation, that kind of talk, which allowed the discussion to happen. But I think he's absolutely right that there's this slight disconnect between what the public thinks and there is a simplicity in what he's saying. And then how does the law and society respond to when someone suffers for doing that? And of course, those in the workplace are already in a vulnerable situation in the sense that they have a job on which they rely for their livelihood. And so that is one of the first places that the laws have been easily understood and applied, because you can deal with the fact that someone might suffer and can really affect their lives and their ability to operate in society and to continue to work and work for their, you know, for their families and for their well-being. So that is where most of the laws are focused. But there are other ways in which legal protections need to develop, because that's not the only way and the only that people suffer for speaking up.
Yeah, I think those are wonderfully succinct definitions, and we can certainly see how they apply to vast areas of the federal government, the corporate world. We think of institutions like the SEC. I guess the wrinkle in this comes with regard to national security, and when we're talking about classified information, we can get onto some of the protection mechanisms a little bit later. But I just wondered what your thoughts are with regard to the national security whistleblower, which probably looms largest in the public conscious. We mentioned Ellsberg, some of the more recent examples like Edward Snowden, Chelsea Manning, Reality Winner, Daniel Hale, a number in the 21st century, who many will be familiar with. Yet they are not considered by the state to be national security whistleblowers. They would be termed cases of unauthorized disclosures, leakers, traitors, snitches. I wonder what your thoughts are with regard to why the label whistleblower is so contested when it comes to officials working in the national security space.
Oh, I can start again. Actually, the world's whistleblower laws generally don't make a distinction between national security employees and other whistleblowers. Only about a third of the world's whistleblower laws put them in a separate category. Most of the laws have more limited disclosure rights for national security workers, but the same anti-retaliation protections. That's not true in the United States, where their rights are very, very weak. Although it's officially illegal to retaliate against an intelligence community whistleblower, in practice, it's very easy to get away with it. And as far as their role, national security whistleblowers are extremely important for any country's defense. Abuses of power, which are sustained by secrecy, can be a clear and present danger to national security. And most all the whistleblowers that we've represented were people who were trying to plug leaks in our defense system, not be leaking information about the government. They were trying to make sure that the government was there when it was needed. I'll give two examples. One is Robert McClain. He was a federal air marshal. He discovered that the Federal Air Marshal Service was canceling all of their missions and protection on the eve of a more ambitious rerun by Al-Qaeda of 9/11. This Al-Qaeda attack, which had been exposed by Saudi intelligence and confirmed by U.S. counterintelligence, was not only targeting the capital in the United States, cities up and down the West Coast, capitals throughout Europe, London, Rome, Hamburg, even Canberra, the capital of Australia. I mean, the grand finale of skyjacking. And our Air Marshal Service was going to go AWOL due to political corruption while this attack happened. He exposed it. Within 24 hours, the mission was restored and the hijacking was prevented. Or the chief science advisor for the Marines in the United States, Franz Geil. He was a whistleblower at the request of the chief general in Iraq because we were losing so many troops due to failure to deliver vehicles which would adequately protect the troops against landmines. We bought these vehicles. They were just gathering dust in warehouse, again, due to political corruption. They weren't being delivered. And 90% of our casualties, 90% of our fatalities in Iraq at the time, 60% of our casualties were from landmines. Thanks to a whistleblower, Mr. Geil, the vehicles were delivered and the troops needed, and our landmine casualties went down to 5%. Whistleblowers are essential for the defense of any country when the military bureaucracy is abusing its power at the expense of its mission.
I think it is interesting what Tom is raising, because certainly if you think internationally, and if you look at I put in the chat a case, Grand Chamber judgment in Guha versus Moldova, which was one of the first what we sort of could see as a whistleblower case at the European Court of Human Rights, and that was someone working in the prosecutor's office, so there isn't a distinction between those working with national security, because within the European Court of Human Rights, they're looking at it from a freedom of expression and human rights perspective, which covers everybody. I think what will happen is obviously a balance in these cases where someone has spoken up out of these areas, and what is the extent to which the secrecy, other risks and other harms have occurred by the breach or the breaching of confidentiality. So it is always saying that it's can never be absolute. And if you think about when we think about authoritarian governments, you can see where the idea that it's labeled official secrets or it's considered by the state national security, we would say, well, actually, though there's an overreach here and they're covering way too much, and that's not in the interests of the people or the country. So I think one of the great pieces of sort of a resource that was developed around it, and it was actually pushed forward after Snowden's disclosure, because it was on the cards and everyone was working on it, on the Schwanny principles, which is the principles of national security and right to information. And they published it faster because of Snowden's case coming out, and thinking, actually, we need to get this out there, where they're really talking about this, that you can't have any absolute bar against going public. But obviously you can, what you also need to do is make it really clear what is essential information that you would classify for good reason, and that debate still hasn't been had. So we end up having a discussion about whistleblowing that isn't dealing with a fundamental issue, which you start with. And if you remove those people right out of, or a category of workers, or anyone subject to official secrecy, you will miss really key disclosures that the state actually probably doesn't mind that, or needs to know. And in other countries, that government would say, absolutely, those are the kind of things that those citizens should be able to speak up about. So we all know that in each of our countries, the closer it gets to the people who they will laud it when it's happening elsewhere and find it harder when it's closer to them. But it's the rest of us that need to keep them honest about those limits and their powers.
I think that idea of sort of upholding the rules, upholding sort of accepted norms is interesting, even from a historical sort of perspective, because that the metaphor of the whistle as a tool to ensure that rules are followed are rooted in the 19th century, particularly in sports and policing. The first sort of football games, or soccer for our American colleagues, the whistle was the tool that the referee uses when there is an infringement. You also have the whistle that's used in policing in the UK. The London Metropolitan Police have a competition to create a whistle, and the whistle that wins this competition and now becomes sort of the standard for use in policing and also in sports is the Acme whistle. Again, the idea of the shrill blast of the whistle is calling attention to rules being broken, and it's interesting how that idea continues in many ways through to the present.
If I can just jump in there on language, just very briefly on the whistle issue. Recently, as countries and different cultures are coming forward to discuss this, one of the things that NGOs and nonprofits have talked about is the words that are used, and to kind of find a neutral or even positive term in their own languages. So a number of years ago in Poland, civil society started to use the word signalista, which means sort of, obviously it sounds like a signal, but it's an archaic term for Navy warnings to other ships. So it's not just calling out to stop something you absolutely know, but it's warning that something might happen. And I think that leads back to exactly what Tom was talking about at the beginning, this kind of finger pointing, or actually just saying, isn't this wrong, are both within the realm of whistleblowing as we would identify it, but also that civil society will start to use those words when they are talking to governments, and then governments have started to use them back, because it's easier than in some of their countries. The legal definitions are very narrow, or the cultural definitions, there isn't one, because they've had to come from a background of authoritarianism, or just the idea of whistleblowing hasn't been part of the history of their nation state.
No, there's nothing magic about the word whistleblower, as I think Anna's illustrated. One country called lighthouse keepers, after those who shine the light on the rocks that would sink the ships. Other countries are called bell ringers, to people who go to the top of the church and warn the town of danger. The freedom to warn is a very significant aspect of why people blow the whistle. They either want to stop the bleeding or prevent it from happening in the first place.
Yeah, it's fascinating how there are different terms in different cultures, and there are some languages that don't have a term itself. Italian would be one example. But it's interesting because we assume that the term has been around forever, but it has very uneven use in politics, in literature in the 20th century. It's really the 1970s that it becomes popularized and enters mainstream lexicon. Ralph Nader perhaps does more than most to help bring this idea of blowing the whistle against bosses and wrongdoing to the mainstream. I wanted to turn to the question of sort of the role of whistleblowing in relation to democracy. Tom, in your long experience, what would you say has changed in terms of how whistleblowing is debated? And could you sort of sketch out your approach in terms of how you advocate for whistleblowers?
Oh, sure. I mean, In real estate, the magic word is location, location, location. For whistleblowing, the magic word is consequences, consequences, consequences. The key for whistleblowers, one of my first clients, a gentleman named Ernie Fitzgerald, who was kind of a pioneer of Pentagon national security whistleblowers, called whistleblowing committing the truth. So you're treated like you committed a crime. And in my experience, the magic word for getting away with committing the truth and having an impact is solidarity. The fatal word is isolation. If a whistleblower comes into GAP and is all they've got is great evidence and strong legal rights, I tell them you're in big trouble. You have to have a base in society that's rallying behind your dissent. If you're going to survive professionally, and if you're going to make a difference, if you're going to have an impact, and that to me is the key. Abuses of power are the greatest threat that exists to democracy, and people can't defend themselves if they don't know what's being done to them. That's why abuses of power can generally only be sustained by secrecy. So at GAP, I mean, we're lawyers, and we always have a lawsuit going on, but we don't just do cases. We do legal campaigns where our organization plays the information matchmaker between the isolated whistleblower, who is in a very, very vulnerable, precarious position, and all the stakeholders in society who should be benefiting from that person's knowledge if they only knew what was being done to them. And so we get the word out to both parties in Congress, to law enforcement from the federal to local level, to the community organizations, to the national NGOs, to the competitors of that group, to the media. And when that happens, when society becomes informed, instead of a corrupt bureaucracy, bullying bureaucracy surrounding a lonely whistleblower, it's society surrounding that organization, and the balance of power shifts, and the truth becomes more powerful than conventional authority. So we apply that in terms of getting stronger legal rights. It's not, we don't say, well, this is a matter of civil liberty. We don't say that if it's going to work for the audience. We talk about the consequences. We need whistleblowers so these tragedies don't happen. These tragedies could have been prevented if people hadn't been too afraid to speak out. That's, to me, is the key to whistleblower advocacy, is getting the word out on the consequences of secret abuses of power.
Anna, I wonder if you could tackle this admittedly big and tricky question, but an important one, of what the relationship is between whistleblowing and democracy. How does supporting whistleblowers bolster or strengthen democracy?
Well, I think picking up on what Tom said, a major aspect of whistleblowing is the public's right to know. And so in the end, so even though there may be ways in which a whistleblowing disclosure can be dealt with internally or within the accountability mechanisms that many societies will have in place, like regulators or even members of parliament, law enforcement, et cetera, and it's not necessarily going widely public, although I think by the time it gets to Parliament or to Congress, for instance, it is. But I think if you think about it in terms of democracy, I would have said maybe it was a little bit of a conceit for a little while, and Tom would just laugh. But there was a sense, I think, in Western countries, certainly, that whistleblowing was your backup, that this was to back up the institutional accountability mechanisms that worked for the most part. But I would say that, it really hit me hard at an open government meeting where you had a lot of people very upset after the Snowden disclosures and realizing that surveillance had gone worldwide. And of course, that also showed a lot of us around the world that, while we weren't even getting our act together nationally to get whistleblower protection, basically the problems were global. And I would say that's become more and more obvious with corruption and some of the corruption scandals now, and whistleblowers raising things that cover many countries, whether it's the corruption that is happening with Western companies operating in Africa or Latin America and lots of different areas. So I think one of the things that we started to see, and in those discussions years ago where the sort of Western Northern experts were going, oh my God, this is terrible and we need to do something. And somebody from South Africa turned to me and said, well, wake up and smell the bloody coffee, especially around national security. The idea that national security was used to stop any questioning in many countries of the world of infrastructure projects. Not, and just saying you don't need to know about who's building this nuclear facility or who's doing these things. So to me, it stopped being very quickly a sense that it was a backup to realizing how whistleblowing can be a front line of defense for accountability mechanisms and democracy. And to me, ultimately, democratic institutions are our institutions. And so we need to know that they're working, and whistleblowers give us the information. So one of the things that I would say is, I was asked, I think I was in Estonia doing some training with local authorities, really a small thing, but Snowden again had the disclosures that hit, and suddenly the major newspapers in Estonia wanted to talk to me about Snowden. And I was like, oh, okay. And they were saying, is he a hero or a traitor? And I said, well, that's not the first question I ask myself. And obviously the story was new, so lots of people were digesting it. I asked myself if I wanted to know. And I did. So if there's and that's a starting point to work back, what are the mechanisms that mean that this kind of disclosure is the only way to help us? But, even though I don't want whistleblowers to be alone and I don't want to rely on them, by God, if they're going to take that risk, I think we need to stand with them. So I think the idea that it is really a human, an individual's ability to connect with the collective to say something's going wrong for all of us. And so to me, it's the essence of democracy and democratic accountability.
In many ways, that's the key question there. How does the public know what the government is doing? Do lawmakers provide adequate accountability? Do the press? If we think about the American context and the British one as well, it's a mixed record there. Whistleblowing is in many ways imperfect, but sometimes it's the only form of accountability. And I think in many ways the debate should be around that question rather than, as you said, the one that is often raised, is X or Y a hero or a traitor? That's in many ways beside the point. The key issue is the revelation, right? Rather than trying to psychoanalyze individuals. I want you mentioned the issue of sort of protection, so I thought we could sort of go into that in a little bit more detail, because there is a host of sort of protection mechanisms out there, but there are certain restrictions. Some people enjoy some kinds of whistleblowing enjoys more protection than others. So I wondered whether you could take a moment to explain, well, firstly, why whistleblowers need protection and what is out there, what works. Thinking particularly of the US, what is the US doing in terms of whistleblower protection? Tom.
Well, as far as why they need protection, it's to neutralize a basic animal instinct. When animals are threatened, their instinct is to destroy the threat. It's not a matter of good or evil or anything else. It's survival instinct. And we do happen to be animals. So when our institutions are threatened, the instinct is to destroy whoever is causing that threat. And whistleblowers are threatening the self-perceived, sometimes short-sighted, but self-perceived interest of the organization. And it's just part of who we are. Like if somebody slugs me, hits me, my instinct isn't to talk to them about why they did it and to see what we can do so it won't happen again. I'm going to hit them back as hard as I can. Because number one, I don't want to give them a chance to do it to me again. And number two, they hurt me and I'm upset about it. And whistleblowers are dealing with that basic reality, which is why we strive for them to present themselves as problem solvers rather than finger pointers. As far as the rights in the United States, they're highly imperfect rights, although it's become something where I think we have won the cultural revolution, and there's been all sorts of legal activity and a legal revolution, but they're not reliable. I mean, so I'll go over some of the positives and negatives about our country, and Anna can discuss in depth what's happening in Europe and other nations. The U.S. deserves credit where it's due for pioneering the whistleblower right. We were the first nation to pass a national whistleblower law. We pioneered fair legal burdens of proof, the rules of the game on what it takes to win your case. If those rules are rigged, the rights are a fraud. We pioneered rights that help whistleblowers make a difference, not just defend themselves. America's False Claims Act is probably the world's most effective anti-corruption law. And our Whistleblower Protection Acts in 1978 started what's evolved into channels for whistleblowers to present their evidence and make a difference through official institutional checks and balances. We pioneered supremacy of law, where our whistleblower rights, they supersede, they trump any non-disclosure agreements, gag orders that would cancel those rights. And America is still the world's strongest whistleblower rights for public freedom of expression. In Europe, you have to wait 3 months unless there's certain emergency circumstances that you can't count on winning until the case is over. In the United States, you have the right to go public immediately unless the information is classified or its release has been specifically banned by statute. Those are the positives. The negatives, and I kind of view the U.S. as, well, we were a pioneer whistleblower law. Now we're kind of a dinosaur whistleblower law compared to the rest of the world. We're limited to administrative remedies for our government workers, not corporate, but the government workers. And they don't have access to the courts to get there to seek justice. And those administrative remedies can have a real conflict of interest. Our laws are a complete mishmash. We've got in the United States 60 whistleblower laws that still don't cover everything. They're hit or miss. Other nations have 1 or 2 whistleblower laws that are comprehensive, and our laws aren't all alike. They're all different, like snowflakes. I mean, you need an expert navigator just to tell you what the boundaries of your rights are, because they're so convoluted. We have 4th-class national security rights, although they have the principle of freedom of expression, and the enforcement is almost like a fraud. Our track record is only half as successful as other laws, whistleblower laws in the world. There's in the chat, there's a report the Government Accountability Project did with the International Bar Association, and it tracked whether whistleblowers win their cases when they assert their rights. Globally, it's about 20% who get official victories. In the United States, it's about 10%, really falling behind. And finally, the U.S. whistleblower rights don't cover anything except workplace harassment. 2/3 of the world's whistleblower laws, and nearly all of them passed in the last decade, cover any form of retaliation that could scare you into silence, including retaliatory civil or criminal prosecutions, slap suits or criminal prosecutions, both of which can be a lot scarier and have a worse chilling effect than just getting fired from your job. I think everything in life is the sum of its contradictions, and the U.S. has some very deep ones.
That's fascinating. And before we turn to Anna for her perspective, I just wanted to sort of follow up on that with regard to the US and particularly sort of classified information. You mentioned how there are many whistleblowing laws, but it's quite ad hoc. And the same goes for even secrecy. National security information or state secrets are sort of almost taken for granted today. There's an assumption that they've been around forever, but it's a very modern phenomenon. Very much a 20th century one. The classification system only emerged in the early 1950s. They're presidential executive orders. The Espionage Act, the tool that's used against most, every almost, national security disclosure is rooted in World War I laws. And then you have numerous other sort of episodes. In short, what we consider to be the secrecy regime is a very ad hoc, improvised structure. But John, you mentioned particularly that there are a number of issues when it comes to national security and intelligence community whistleblowing. One of the big sort of changes over in the 21st century has been the idea of the insider channel that has been trumpeted, particularly by Barack Obama, as being the way for people working in the intelligence and defense sector to be able to raise concerns. I wonder if you could tell us a little bit more about those, because they seem to be quite significant when we talk about your Snowdens and your Mannings and Winners. We could just sketch out how they function and some of the problems associated with them.
I'm sure that Anna can add a lot of details, but I'll give a kind of an overview in principle. Channels are the positive about channels is that they're establishing a structure for whistleblowers that's part of all organizations, particularly in Europe. And when organizations start to establish offices and agencies or bureaus or entities around a particular principle or right, it means that that right is taking root. It's no longer something just for people who are nutty or traitors or gadflies. This is not something which is being accepted as part of society's norms, and that's very positive. The negative is that these channels can be very vulnerable to turning into threats for their official purposes. I've had so many whistleblower clients who worked in the channels, and they got the whistleblower treatment because they were backing the whistleblowers. And those channels generally don't have the organizational clout or juice to stand up to the branches of the institution that are abusing their power. And so they become endangered if they back the whistleblower. They get the whistleblower treatment themselves. That really means that you have to structure these very, very carefully. Or else you get into the dilemma where either the channel will become like a plumber's unit, which is actually an arm of the organization's power structure and is identifying potential threats to the organization before they go outside. And that can be like the equivalent of obstruction of justice. That's why it's not mandatory in the EU directive that you go to an internal channel first, because they might be, you might just be, giving the advance warning for a cover-up instead of for corrective action. If you do have the channel, you want those people to have protection against retaliation for all of their work with the whistleblower. They have whistleblower status for working on whistleblower cases. That's very important. They have to report to the organizational chief so that the buck can stop where it needs to. They have to have adequate resources and access to information so that they're not just, on the outside, unable to look in and follow through on the whistleblower's disclosure. They have to be free from institutional conflicts of interest. They have to be full-time jobs. Like in Serbia, some of the folks staffing the channels was in charge of the tourist bureau. And oh, by the way, you're also the whistleblower channel. It has to be dedicated full-time positions. They have to be well-trained. This is a very, very serious initiative. And it's one that could truly integrate whistleblowers into having the most impact, or it could be a severe threat to whistleblowers, depending on how it's implemented.
Yeah, Anna,
Yeah.
I want to turn to you on this question of what works and why when it comes to whistleblower protection.
Yeah. So two things. There's the rules and laws and the evolution of those over time and what has been added and the understanding, and I'll talk briefly to that. And then there's the other side, which I think just is crucial and can never go away. There's not going to be a Shangri-La, we arrive and the laws are perfect. It really does depend on what Tom said at the beginning around ensuring that there are more people knowing about the information, that are affected by the information and stand with the whistleblower. So solidarity and strategy is always going to be absolutely necessary. And that's where WIN was set up to deal with this, because we were aware over many years and talking to Tom over many years that there were these national organizations. They've been doing a lot. They were understanding how power works in their countries. Laws were developing, and we needed to share that expertise. And then, as I said, it became so obvious with a number of the more recent national security whistleblowers, but also just knowledge really of how power was corrupting across borders through all the supply chains, and really realizing that we needed to operate together, not just to share the expertise north, south, east, west, because we can learn from each other, but we can connect so much more easily, and we can collaborate on all many levels of what the whistleblowing disclosures might be telling us. So that's that I have to say, because I won't ever go away, the need for the support and some people who can help whistleblowers navigate a system, because it's always going to be a bit more complicated. Channels are really interesting. To me, if you look at it from the European Court of Human Rights kind of perspective, human rights, you have these areas where, of course, the closest to the problem should address it, and that would be simplest, and that's the preventive, and that's where you want to make sure that the barriers to ultimate protection if it goes wrong are really low, because what are you breaching? If you're telling your employer about what's going on in the employment, you are not breaching most rules of confidentiality at all. So the idea that you get into this discussion. So I think there's been a little bit in some of the laws getting that a little bit wrong. Sort of taking some of the external view and kind of going, there should be, it should be in the public interest, even if you raise it with your employer. And in fact, most employers will set up systems and say, we want to know everything that's going wrong, and makes sense. So the law backing that up, that if you use those systems and you're raising a concern and you are, reasonably you don't have to be absolutely right. You just honestly you're not using it to blackmail your employer. You should be protected. And then the other channels that are obvious are all the accountability mechanisms. So outside of employer are regulators, are those who are reviewing what different companies and state bodies do. So you should be able to go directly there too. You're really not breaching the accountability and confidentiality if they have a role in regulating that sector. And then it's the wider disclosures. And again, the rules should be quite clear that those are available to you. But even for most individuals, if you said you can go immediately to your MP or to the newspaper, they'd go, what? It's a problem in my workplace. Not sure what they can do about it. Who else can I go to? So the discussion that many of the advocates and advisors around the world will be having is, what's the problem? How serious is it? Who do you want to tell, and what's stopping you? And you work from there, because then you see what those channels are. So when employers are being required, and under the EU directive, all employers with over 50 employees have to set up some of these channels, have that availability. We're going to have to really monitor how that is being transposed nationally, if it is becoming these kind of corridors that you must use in order to get protection, or it being understood that way, because that could become easily a trap for people, where they need to be able to go to the person who can handle it and who can deal with it the closest and the easiest as possible. So crafting these laws to deal with the channels, I think, is a really interesting one. I think the channels are really important. So if you look at and where they work as well. If you look at the case of, you may recall in the UK, Caton, the Jess Staley, who was at the time head of Barclays Bank, and there was quite a sophisticated whistleblower system, I think run by a former police officer, which is what is happening in a lot of these big institutions. They've got lots of duties, they run these things, and they had set up a system so that the senior management, the CEO, wouldn't know who was raising concerns, and it was dealt with. There were reports to the board, but it was actually quite well set up. And there was a case that raised a concern very close to the CEO and his circle, which of course did exactly what Tom did, was suggesting that people react when they feel attacked, but also just it was questioning the judgment of people who are probably not used to being questioned very much. It was dealt with properly through, but it was about some sort of, I think, recruitment process. So it was dealt with properly through this channel. And then Jess Staley tried to unmask and reveal the identity, even though it wasn't taken any further. And in doing that, and that going public, he basically undermined his own whistleblowing system and was fined by the FCA and I think also by the Americans. So you can see that when you have those channels and they are actually meant to work, they can also act as a way of holding the organization to account for how they're doing. And I think that's a couple of things with the EU directive, which has set some of these requirements. Basically, it still covers those sort of related to the workplace, but it's wider than workers. It can cover those who facilitate whistleblowing disclosures within the workplace, and it can cover family and friends who are somehow caused problems by the whistleblower. As Tom said, there are other protections. So it's a wide range of detriment and harassment and things that can go wrong, lack of promotion, all sorts of detriments in the workplace where that you can show, and it's up to the employer to say whether or not. So once you can show that you raised a disclosure and that there's been some harm, then it's up to the employer to show that it was unrelated and that what they did was fair. At least that's the test that we think. It's not perhaps quite as clear, but it is a reverse burden of proof. So it isn't on the individual to show that that's the reason for the retaliation. It's to show a prima facie case. And there is you can go to your employer or to a regulator. There is a little bit of tests on going public, but that channel is open to you. So and it doesn't carve out any particular form of worker. There are, because the nation states have the power under their own constitutions to deal with national security, that's not an area that the EU could directly put in any requirements on the directive. So there is some leeway there, but again, that doesn't stop the nation states to saying that their national security people can be covered. And in France, in fact, they are in the new transposition law. So it's much broader how they're doing it. And these channels are now a requirement to have, and it puts some requirements on regulators as well on how they treat anonymous concerns, for instance, are protected. And how if they breach confidentiality, they can find themselves actually being fined. So it's putting more of the accountability on the organization, which is where the whistleblower protection should sit. And we can see that happening legally. And I still think we'll see some cases where they get it badly wrong, even in countries that have good laws, but that it'll actually hold them to account in a way that it hasn't been done so far. And 27 member states now have to pass a law, and they have different cultures, different histories. Some are quite adept and have a mature conversation nationally. Some are really still starting out. So it'll be very interesting to see over the coming years what happens in Europe.
We're approaching an hour, so I'd just like to remind viewers, if they have questions, to post them in the chat, and we can pose those and discuss them amongst ourselves. We've started to zoom out a little bit from just the US context, and I wanted to just continue this for a moment. You've mentioned, Anna, the EU directive. I wonder if we could say a little bit more about sort of what that is and specifically how that differs from these debates that take place in the US. What are the key differences between the two sort of systems, if you will, and particularly what are some of the key drawbacks from your sort of experience having seen this directive roll out now over a couple of years?
I think probably Tom can speak more about what he sees as the difference in the US. I think the debates in Europe, there were some cases that really politically pushed the European Union to act. And there was one called the LuxLeaks, which was an auditor who'd blown the whistle in Luxembourg about how PwC had sort of an industrial system of helping the companies and their clients negotiate tax deals in Luxembourg, which allowed them to put their profits through. And that case with that whistleblower, Antoine Deltour, who went public, didn't even follow any of the other routes, but it was just said, I thought it was wrong. And that was basically his reason for going public. And he realized that they were not going to do anything about it because it was part of their business model. And it really caused a shakeup in the EU, along with the murders of two journalists in Europe, Daphne Caruana Galizia and Jan Kuciak and his fiancée. So Daphne Caruana Galizia in Malta and Jan Kuciak in Slovakia. And though they were murdered mostly for what it seemed to be the fact that they were investigating corruption. So interestingly, the LuxLeak case and those murders were really the catapult for the European Union to start to really address it. And their big debates, I think, at that level was just whether the European Union had the power to do so. But once we got through that, then it was quite amazing how fast they went and how they were dealing with, they were saying things like it has to cover a wide swathe of information. It can't be this. They learned from a lot of countries that when you have all these laws and it gets to become a patchwork of protections, that doesn't help the whistleblower, doesn't help anyone. And so they guarded against that. But again, they have limited powers in what they can tell their nation states to do that are part of the EU. So there's elements in which it won't happen because it will look ridiculous if the actual states in the EU say it's only to do with EU law. Like if you're in a workplace, how do you know if it's a breach of EU law or just normal wrongdoing? So that's sort of going to be dealt with. But I think they were dealing with anonymous disclosures was difficult, but actually they went ahead and they do protect anonymous disclosures. So if somebody is identified and is retaliated against the fact that they initially raised it and it was dealt with as an anonymous disclosure, they can get protection. That was a big area of contention. This issue of this wide amount of information is covered by those laws. Yeah, I think what we're going to see and the choice of channels, that was our red line, and that was a big debate. And in Europe, it sort of made sense to all the policymakers and the permanent reps that you should have to go internally first, which just undermines whistleblowing. You have to have the backup. That's what this is about accountability. It's about, yes, you want to make it as easy as possible for people to raise it internally, but they can't be forced to do that because that's the problem now. And that's where, if they don't have any rights and protections, they feel forced to break the law to raise concerns, and that doesn't make any sense, or break confidentiality duties to their employer. So that was a big debate, and Tom was very helpful with us to really push the advocacy forward and to explain what this was about. That it really wasn't about making people go outside, but making sure that they have that option to go externally. So those were the main debates, and it'll be interesting to see how many, as we go forward, even though some of the laws have done a pretty good job, they're not necessarily taking it as they should and falling short on some of the requirements. So many of the member states have already been referred to the European Court of Justice, for instance, for delaying the transposition even of the laws into their national jurisdictions. And there has been some interventions already on failures to meet minimum requirements that has caused, for instance, Romania, which actually adopted a law in Parliament, sent it almost immediately right back because the European Commission said they were already in breach. So you can see that they're still grappling with the actual understanding of the concepts and applying it within their national jurisdictions, particularly the further east you go. But perhaps you would say maybe even the further south you go. But it's not because the north is any better. It's just they've been having a longer discussion, I think, on these issues.
Tom, you can come in on this. What do you see as some of the biggest differences between the EU directive and some of the discussion taking place in the US, and some of the biggest problems as well?
Well, I'm envious of the EU directive in several respects. One is this creation of mandatory channels. It really forces it makes whistleblowing legitimate rather than something which is sort of outside the norm, and it forces whistleblowing into the infrastructure of all organizations. And it's created a very active market around whistleblowing. And all of that is healthy for freedom of speech. The second thing is that the EU directive covers the full scope of retaliation. Protecting people against slap suits or criminal prosecutions is all important because those are worse forms of harassment than just firing someone. The third one is a stronger burden of proof. In the United States, the whistleblower has to, for their burden of proof, they have to prove a connection between their whistleblowing and what happened to them. They have to prove that link. We call it the nexus legal term. In Europe, they only have to prove that they were valid whistleblowers and that that they had something which prejudiced them that happened, that they were harassed, and then the burden of proof is on the organization. And in the United States, the organization can prevail if they demonstrate that they would have taken the same action for independent reasons, just sort of like net. Like maybe 49% of our motivation was to retaliate, but 51% of it was for innocent reasons. So we still win. In Europe's whistleblower directive, whistleblowing can't be linked in any way to the final outcome. So the rules of the game are much stronger there than in our country. And then fourth is court access. In America, the corporate workers do have court access by and large, but the federal government workers don't. And that's one of the cornerstones of the EU Whistleblower Directive is access to due process that way.
And it covers public and private sector workers. There's no distinction.
Yeah, theirs is uniform rights for everybody, as opposed to the US where, depending on your profession, you've got to get a new roadmap of what your rights are.
Yes, the way this issue plays out in different contexts is fascinating, because it's not just a legal one, it's a cultural one as well, as you mentioned, Anna. And if viewers are interested in more about this, there is a podcast series that Anna and myself helped put together. Perhaps we could put the link in the chat, which talk about these issues with regard to the US and the UK, but also beyond within Europe and particularly Latin America. There are a couple of questions here in the chat that I'd like to pose. So we have one here asking the panelists the question is, do most whistleblowers take pride in their efforts to right wrongs? And what portion would you say regret taking action?
That's a good question. Tom, do you have we haven't done surveys in that sense, but
we haven't done a survey, that kind of figure out the balance of it, but it's gone in both directions. There's a number of whistleblowers who have been to hell and not completely come back, who wouldn't hesitate to do it again. And there's other ones who think it was the worst mistake of their life. I think probably the most insightful answer to your question is, why do they do it? Whistleblowers they're at the crossroads of valid but conflicting values that we're all raised with. Like we're all raised that it's good to be a team player. We don't like troublemakers or naysayers. But on the other hand, we're raised that we don't like bureaucratic sheep. We respect people more who honor their own, think for themselves, honor their own values, who are rugged individualists. That's the whole point of freedom, that you don't have to just do what everybody else is doing and telling you to. We're raised that we don't like squealers or tattletales or rats. But on the other hand, we don't have much respect for people who don't want to get involved, who look the other way. One of America's greatest shames was when a woman got raped and murdered on the streets of New York, and all the people just closed their drapes. See no evil, hear no evil, speak no evil. That's a monkey. It's not a human. Whistleblowers have to decide. It's a tough choice, or the right to privacy versus the public's right to know. Probably the toughest one for them is loyalty. Loyalty to whom? Like, we're all raised that our highest loyalty is to protect our loved ones who depend on us. And you lose your job, you may not be able to support your family. We're also, there's loyalty to our coworkers. You're blowing the whistle might cause the company to go out of business or the agency to have its budget cut, and you may spend more time with your coworkers than you do with your family. But on the other hand, what about loyalty to your community? and the consequences that are happening to the world that you've got responsibilities to, or loyalty to the law, you may be a co-conspirator because you joined the cover-up instead of speaking out when you knew better, or loyalty to your nation. Ernie Fitzgerald told me whistleblowers are closet patriots. Most of them are motivated to defend their country when the bureaucracy isn't. Whistleblowers have told me they did this. They were having nightmares at night when they knew that our helicopters weren't going down in Afghanistan from the Taliban. They were going down because the parts were faulty, were shoddy. There was fraud in the construction of those helicopters, and he knew better, and he couldn't live with himself. And that kind of gets to the bottom line of why do they do it? As one of my clients told me, said, Tom, I'm going to be shaving the rest of my life, and I've got to be able to look myself in the mirror when I do it. They do it because they have to be true to themselves, for better or worse. If they kept all their knowledge inside of themselves, it would be like a cancer eating away at them. And if anything ever went wrong, it would haunt them. That's to me, it's one of those life's crossroad choices.
It's never going to be without risk. But you can come out the other side feeling like you were supported a little bit more, or you weren't the only one. I think that's what we can offer, and we should be offering as advocates for whistleblowers, is that feeling of isolation. We need to help them not feel that, and not be that. I mean, that's I think a lot, you will find there's a really interesting book, and I don't have the link, but I can provide it later, that Kate Kenny wrote, a professor at the University of Galway, and she interviewed a lot of whistleblowers. And what they said is they wish they just had some strategy that they'd actually thought about, because a lot of people walk into that fire. As Tom said, they just do it because they believe it's the right thing. They're often very shocked at the reaction, and it's the reaction that it starts to make them wonder. And the most hurt or damaged people I've met are the ones that were so loyal to their companies. Like, companies and the organization just failed to address. These were people who would go to the end for them and for that organization. So the breach of trust for them is massive. But some of them, like Tom said, will have suffered a lot and still would do it again. I think it's, it behooves us to be with them. And I think I did want to sort of mention quickly that these issues are traveling around the world, and years and years ago, I did a workshop with my little PowerPoint about this new law in the UK, and was asked to go to Nigeria to talk to them. And I, of course, learned far more at that meeting than I would ever have learned anywhere else, because what people were saying was it was worth it when their whole communities could be wiped out. Their lives were being threatened. We have cases now, and have been going on for a long time, where people are being threatened with their lives in Africa and Latin America and murdered. And if they believe that it's worth putting themselves out there, then my God, we should be there. And we should also be addressing the issues that take that to that point. So I do think most people do it because they want to make a difference. They don't necessarily do it because they know they're protected by the law. And they often, that's a backup, that they find out that some of them find out they're a whistleblower, quite a bit after they've done the whistleblowing. But I've seen people be completely isolated and in a very difficult position, who, when the disclosure, in particular, the information that they gave, is taken and substantiated and given credit, you can see them breathing. It's not just theirs. And so someone like Antoine Deltour, who I mentioned, the LuxLeaks whistleblowers, fought for his professional survival and for his freedom for 6 years through the courts. But he started off a scared man, and by the end had held his head high, not because it wasn't terrible. No one should go through what he went through, but people were standing with him. And he wasn't alone, and they were at the courtroom and they were outside the courtroom, and the European Union said that what he'd raised was something that was illegal. There was so much that happened around tax justice that he wasn't an isolated figure anymore, and that matters.
There's another question that's come up which relates to sort of some of the themes that are coming out, and that is a question to the panel asking you to talk a little bit more about some of the whistleblowers who've most inspired you, and why. Tom, you perhaps have a very long list that you could dip into. I wonder if there are some that have inspired you in particular.
I should say an overview that some of the whistleblowers who have been the most effective have been the most difficult to relate to. The first study that I read about whistleblowers was entitled "In Praise of Difficult People." And those who want to challenge an abuse of power by a powerful institution, from their own individual perspective, they're generally pretty feisty people, or they're, this one who are making allegations, not just trying to do their jobs. Pretty feisty people. They're not that well adjusted. Happy, well adjusted, well balanced people usually aren't going to take that risk. So it takes a unique sort of person, and they can be very challenging working relationships. They can be. And then there's people that just are my inspirations. FDA scientists who exposed that 80% of commercial milk in the United States had illegal animal drugs in it. And he got a national milk testing program as a prerequisite to selling commercial milk. Well, he was such a humble, inspirational person. I would have him watch my children when my wife and I wanted to get out of the house. I trusted him so deeply. Some of the climate change whistleblowers, like James Hansen and Rick Peltz, they're willing to risk everything to warn that our planet was in danger. There was an FDA scientist who got Vioxx off the market, which, although the FDA had declared it officially safe, it had killed close to 50,000 people with unnecessary fatal heart attacks. And his testimony got it removed from the market. Dr. David Graham, is a leader in the Boy Scouts, a community leader, a dedicated family person. People who became my role models over and over again. And then there was other people who became my teachers in how to survive difficult relationships. So it goes in both directions. And I think your point earlier was very well taken. It's not whether the whistleblower is a nice person or a jerk. It's not whether their motives are noble or self-serving. They're the messengers for the truth. It's what they're communicating that the public needs. So when I have a whistleblower who's a type A personality, it's not as much fun as when I have a whistleblower who's a role model. But what matters is the information that they're sharing with the public that we need to know.
Yeah, no, I can think when I worked in London at Public Consumer Work, now called Protect, and was on the advice line. It was someone who called, who was an anaesthetist and who was basically preparing all the patients of a knee surgeon as if they were going to have open heart surgery because of the amount of blood they were losing. So he was protecting all the patients, but this was a consultant and he was an anaesthetist. He gathered the evidence and then he raised it. And the way he raised it, the way he said it was, I'm not a consultant. Here's the information. But in all my years of practicing, I've never seen anything like this, and I thought you should know. And that not only did he survive the whistleblowing, but it was very, very challenging. But he actually, was promoted, not on the, and he was very open about his whistleblowing. And he was someone who just, on a personal level and he dealt with it. And I was the first person he said that I said, oh my God, this is amazing. And you've done the right thing. So there are people like that who they almost don't need help. They need help, but they're where they're sitting and how they're doing it is really inspiring. I would say recently some of the whistleblowers in Africa that I've met who are raising concerns around very serious issues of exploitation of natural resources, or are raising issues around corruption and the exploitation in the fisheries, and are taking their lives into their own hands, and are taking that risk. And not only are they losing their jobs, but they are then having to go on the run, and they're separated from their families, and they're very worried. I think one of the things that Tom mentioned is the loyalty to one's family is the thing that probably hurts the most. And sometimes I'm really aware when whistleblowers are telling their stories, and there'll be a question maybe about that, and that can take years to digest. And sometimes that's the thing that they cannot talk about, even if their families are supporting them. The idea that they put their families in any harm's way or at any disadvantage can be the thing that they can't talk about, that's too close. And so that too, I think, is really important when it's important for whistleblowers to be able to tell their stories, but for people to understand how human it is, and also focus on the message. That helps them breathe. That's why they did it. That's what they're doing. And we can't over focus without, we need to support them, focus on that way, but we can't over focus sometimes of how difficult it was. And those people, do come through. And I'm seeing more people do the work they want to do, go back to some of their expertise, or become anti-corruption fighters in their own right.
There's certainly, we've worked with a number of whistleblowers who are type A personalities, but there's so many that I've worked with who are like angels in human bodies. They're there to help people, and they realize that they could. We've seen this a lot in the abuses of people who are immigrating to the United States and have been kept in detention camps. Doctors who just gave freely of themselves to provide the medical evidence of what it does when you separate children from their families and the impact on society. There was one nurse at a hospital that immigrant women were brought to en masse and given involuntary hysterectomies. They didn't have informed consent for them. They didn't even know it was happening to them in many cases. And she was a single mother. She's been blacklisted ever since she blew the whistle, but she stopped the practice, and she doesn't have any regrets at all about it, because that was her mission as a nurse. So often whistleblowers are really motivated that this is my duty. Whether or not they're pointing the finger or just doing their job, this is my duty. This is my role in life, and I'm going to stick to it.
There's another question here about the extent to which the history of secrecy, whistleblowing is known within sort of the advocacy community. This is a question which, as a historian, obviously is close to my heart, and it's something that we've spoken about at various points. But this has been posed, and I wonder, Anna and Tom, to what extent is the history important here for understanding?
Well, whistleblowing is just a current popular name. This is a timeless phenomenon. As long as we've had organized society, sooner or later, those who had power abused it. And I think of power as like the Ring in the Tolkien trilogy. You can't handle it. It poisons your soul. Even with the best of intentions, after a while, people start abusing it. And sooner or later, they go too far, and people fight back. And if they do it with weapons, they're revolutionaries or terrorists, depending on your perspective. If they do it with words, they're dissenters or dissidents. Now we call them whistleblowers. But Socrates was a whistleblower, and he got executed. I think of Copernicus and Galileo as whistleblowers against the conventional wisdom that the universe circled around our flat surface here. And Galileo spent the rest of his life under house arrest. This is something which has always occurred. It's just that currently it's sort of developed a much more legitimate identity in society. Instead of being the outsider, it's now being accepted as something which is part of the checks and balances of society. And I think it's a wonderful transformation, but it's certainly not a new concept. It's as old as the history of organized society.
And I think new advocates need to know some of the history. That's why, I really responded when we started talking, Caitlin, that people need to know that the laws haven't been around that long, that it hasn't been written in stone, and you don't need to handle some of the arguments used against you as if that's a valid argument, especially if you have history on your side. And there are still people who go into meetings. I know Tom was recently involved in the UN Convention Against Corruption. There's a resolution on whistleblowing protection, and even the US delegates didn't exactly know their own legal systems, and we had to put them right during a debate. So, you'll get people in a room, and if the advocates really understand where this comes from, then they're able to really inform the policymakers, who also have a very short memory. So I think the official secrecy and national security piece is really important to understand how we got here. Canada did, we had the Canadian Mounted Police. We didn't have a secret service until we did. And then they were suddenly part of the Five Eyes. So Canadians hadn't caught up to the fact that because we were not really doing much. We were the peacekeeping forces as far as I knew, but also the idea that our companies are actually doing terrible things around the world and we don't know about them. And probably some of the history would allow us to understand where that comes from. So I think the historical narrative is really important. I think it allows us to acknowledge some of the real issues that do get passed down for generations. So those who grew up in authoritarian states, who genuinely do not understand why somebody would raise a concern without having some motivation that works for them, because there is no such thing as open whistleblowing. It's a state informing, and you would only do it if it was okay for you and your family to do it, or that you had something to get from it, or that you have trouble with anonymous whistleblowing. Absolutely. So the fact that anonymity has been around since time began. It can be the brown paper envelope and then letters cut down, or cut out and put under a door, or it can be a technological fix, but it's still a tool for protection when you don't trust. It's not the end that will resolve everything. And so the history of where we got here from, I think, is really helpful. Can't dwell in it, but it informs some of the debates we're having now in these different countries. And to ignore it is ridiculous. And if you're talking about whistleblowing in former colonies who are dealing with a lot that is happening and saying, this is new, it's not new. So I was told in that meeting in 2013, wake up and smell the coffee. I think we all should. And part of that is knowing our history.
So we are approaching the end of our discussion, but I wanted to pose one final question to the panelists. I started off by asking you how you got into whistleblower advocacy. And I wanted to wrap up by sort of reflecting back and perhaps thinking about what advice you would give your younger self, or perhaps someone who's starting out in this space or wanting to pursue a career in whistleblower advocacy today. Tom?
Oh, my advice is to find your calling. And live it. I've been doing this for I think 45 years now. I'm not sure exactly, but it's not a job for me. I'm able to live my calling, and once you discover it, that's where you should put your energies. And the main feeling that I have, growing up, I wanted to make a difference. And being an advocate for whistleblowers has allowed me to make a difference more than anything I ever dreamed of or fantasized when I was younger. Stopping nuclear power plants, there were accidents waiting to happen, exposing Big Brother surveillance in every American family. All the people that I've championed and helped, they've changed the course of history so many times, and it's happening more and more. And that's, to me, what makes it special to be an advocate for whistleblowers. Is I think we all want the world to be a better place because we were here. It's just a basic thing for people, and working with whistleblowers maximizes the way you can achieve that sort of gut instinct. And the lesson that it's taught me is that, if it's used strategically, there's nothing more powerful than the truth. It's more powerful than money. It's more powerful than conventional authority. It has to be used strategically and effectively. And so that's why I love my work. I don't really think of it as work. I love what I get to do.
Yeah, I
Fantastic.
think briefly to young lawyers is to, you know, have a healthy skepticism about the law and don't think those are the answers. And see it as something you're always going to be learning from. That whistleblowers are they don't come ready-made packaged. They come over the left, the left shoulder, the right field. And so you have to be there with them. So don't be afraid to not know and to actually reach out to other experts and other people who are doing this work, because it is a learning process for all of us all the time. I now feel so comfortable where we get a collaborative group around a whistleblower, and knowing this, I have no idea how to deal with this, but I know who can. So see it as something that you are now part of a wider community. If you want to carry on doing it, it doesn't have to be that you're a lone ranger with the whistleblower, because then you might both get shot. You need your own backups and resources as well. So, I think it's a great career, but it's not necessarily a comfortable one. But the rewards are huge in the way that Tom says, and the fact that you're always learning keeps you, engaged in the world and feel positive about the world. I do think it's really interesting. People work with whistleblowers day in, day out. I don't know if we're pathologically optimistic, because clearly it's not an easy journey, but we do really believe in it because we can see other people joining on. It's not a lone exercise on any level.
Well, it's the most educational job in the world for the things we're not supposed to know. And
that too.
That's kind of special.
Yeah. Yeah.
Wonderful. And on that note, I think it's time to close this discussion. Anna Myers, Tom Devine, thank you so much for your time and insights. It's been a fascinating conversation. Thanks to the Ellsberg Initiative for hosting it, and thanks to you all for watching.
And thank you, Caton.
Thanks for having us.
Great. Goodbye, everyone.